Mr. Sanders, a little earlier than anticipated, but thank you for being ready.
Thank you, sir. Good afternoon. Apologies for I had to leave one link and come into another, yes. Hence the delay. Shall I start?
Please do. Forgive me, I was silent to let you do so.
Thank you, sir. The designated lawyer represents the following officers in the next phase of Tranche 2. So there are two former undercover officers. That's HN1 cover name Matt Rayner and HN122 cover name Neil Richardson. One back office detective sergeant. That's HN32 Michael Couch. And three managers at either detective inspector or detective chief inspector level. So HN39 Eric Docker, HN69 Malcolm McLeod, and HN109. So I'm going to address you today briefly on three topics which we've canvassed in our written opening. The first is the conduct of the hearings, and in particular a number of concerns that we have arising out of the conduct of the previous phase of Tranche 2 in July, the topic of sexual activity and sexual relationships, and then very briefly the topic of the Tradecraft Manual. So to begin with, the conduct of the hearings, sir, as we've set out in our written opening, a key concern raised by a number of my clients who have followed the proceedings or given evidence is that the inquiry appears to be conducting a two-tier process whereby police witnesses are subject to heavy adversarial challenge, often on matters of small detail, and civilian witnesses are subject to no challenge at all. This is, of course, an inquisitorial process. No one is on trial in this inquiry, and no one is less deserving of the same courtesy as anyone else. All my clients have voluntarily given up their time to make statements in an effort to assist the inquiry, but the conduct of the proceedings in July, coupled with the interim report and the statement that you've made that the lessons to be drawn from the inquiry are largely self-evident, has left the impression on many of them of predetermination and of an inquiry that's going through the motions. If an individual has done wrong or could have done better, it is of course right that that is explored and tested in evidence. But in our submission, it's not right that individuals who did what was asked of them, did not misconduct themselves, should be belittled and sneered at simply because they served as police officers in a different era. As we set out in our written opening, the phase 1 hearings of Tranche 2 were listed from 10 a.m. to 4 p.m. The majority of police witnesses, including my clients, were in their 70s, retired, giving evidence about events of 30 to 40 years ago, and being questioned about statements that they themselves made between 2 and 4 years ago. All of them gave evidence for more than 7 hours, and most sat beyond 6 o'clock in the evening. In our submission, it's an unacceptable way to conduct hearings, particularly for this cohort of witnesses, and it's bound to produce fatigue, mistakes, and poor quality evidence. And one of the consistent points being made by my clients who had followed proceedings was remarking on how very differently civilian witnesses were treated. In terms of civilian witnesses, it is of course right that the inquiry hears from women who were deceived into sexual relationships with undercover officers and others who recall interacting with undercover officers. But if an individual does not recall interacting with an undercover officer and is simply giving evidence about a group that was reported on, the need for them to give unchallenged oral evidence is not obvious. The inquiry is not investigating what happened at particular public order events or the maintenance of public order at such events and it's not investigating instances of disorder or the risks posed by particular groups. For example, it's not hearing from uniformed officers responsible for policing events such as Greenham Common, Wapping, or Welling. It's not examining related threat assessments or operational orders, plans, briefs, and debriefs. In those circumstances, sir, we submit that the perspectives of a selection of those involved with groups who wish to engage in the inquiry may be valuable, but it does not need to be heard orally simply for the sake of it, particularly in our submission when questions about public order and disorder are being asked and answered on the false premise that disorder means violence. And this brings us back to a point we've made previously. Public order policing was and still is about ensuring an orderly, tranquil state of affairs where all members of society can go about their business and leisure and use the public highways without let or hindrance. Demonstrations and protests in public spaces can disrupt this and therefore can require a police presence. It is a question of risk and the assessment of risk and the allocation of appropriate resources. Most groups that were reported on by the SDS, they were all lawful groups. Most had, of course, moderate, thoughtful members with no interest in disorder or violence. But this does not mean that protests and demonstrations that they were involved in did not risk disorder or require public order policing. In particular, other members of the groups and other people attending might have felt differently or had a different disposition towards violence and disorder. There was also risk that could arise in connection with a combination of different groups converging on the same protest or demonstration, and the further risk factor of counter demonstrations or confrontations between demonstrators and protests, even if those on one side were entirely peaceful. The SDS was tasked with gathering intelligence that would help with that process. It was not confined solely to the avoidance of riots. So I don't think I need to address you on anything I've said on the topic of the conduct of the hearings. We've given some specific examples in our written opening statement. The second topic I want to address you on briefly is that of sexual relationships and sexual activity by undercover officers. As we've said in our written opening, sir, all sexual misconduct by undercover officers was wrong and should be condemned and not condoned. However, not all of that activity was equivalent, and not all of it represented relationships in the ordinary sense of the term that most people would understand. For example, the admissions of HN12, who was a client of mine before he died, was of one instance of kissing and one of oral sex. HN67 admitted a one-night stand, and HN87 has admitted 2 instances of what he described as sexual fumbling and kissing without tongues. Those episodes, sir, while they involved misconduct and were unacceptable, cannot be described and should not be described as sexual relationships. That's not how most would consider them. During Tranche 2, 5 or possibly 6, depending on the inquiry's findings in relation to HN2 Andrew Coles, 5 or 6 of 37 SDS undercover officers had sexual relationships with members of the public in the sense that the term relationship is ordinarily understood. While this is a significant and unacceptable minority, it means that more than 30 members of the SDS did not. And this is relevant when you come, sir, to consider what managers could or should have known, because of course they were not faced solely with those small number of officers who were misconducting themselves. They were faced with a much larger cohort, most of whom were not. There's no evidence from any undercover officer or former undercover officer that the designated lawyer managers or back office staff being dealt with in Tranche 2 were informed or aware of sexual misconduct by undercover officers, let alone sexual relationships. In our submission, the risk of totaling every instance of an undercover officer who engaged in sexual activity and then counting that as sexual relationships is it gives the impression that all of those were on a par with Bob Lambert. And then it leads to the conclusion of condemning everyone as having been part of the culture of sexism and misogyny. That is not a description that my clients recognize of their time in the police in the 1980s. Taking that approach also cannot explain and tends to obscure the fact that the risk of sexual attraction and encounters goes wider than just straight male undercover officers. You are due to hear evidence in tranches 3 and 4 about sexual misconduct by female undercover officers. And there was also the claim in the True Spies documentary about a gay undercover officer referred to as Steve. Attributing all such activity to sexism and misogyny is an oversimplification. These may have been factors in some cases, but each needs to be considered on its own facts without oversimplification and bearing in mind the complicated psychological factors and impacts connected with undercover operations. So finally, the Tradecraft Manual. And what I'm referring to here is the 44-page Tradecraft Manual with the reference number MPS 0527597. I think there are in fact 2 versions, but that's the document I'm talking about. Much has been made of this document. It was, and still is, an unfinished draft. Some parts of it are written in the first person as a personal account, and some are not. There are different versions. It has never had the official status, endorsement, or use that many have assumed. And in our submission, Tranche 2 is the first opportunity that the inquiry will have to explore this and hopefully clarify it. You'll be hearing evidence from HN2 and also HN10 Bob Lambert, albeit that his evidence about the Tradecraft Manual might be in Tranche 3, I'm not sure. But in our submission, it is important that some of the myths about this document are dispelled. It didn't have the official status, endorsement, or use that many have assumed. So I think that's all I need to address you on, and thank you for your time.
Thank you very much. Because Mr. Skelton and Mr. Sanders have been commendably succinct in their submissions, the time allowed for them has not been fully used up. It was intended that there would be a break at 1:15 and a resumption at 2:15. I am now going to rise and propose that we resume at 10 to 2 rather than at 2:15. Could I therefore ask Mr. Sheldon, King's Counsel, who is going to make submissions on behalf of the Home Office, Mr. Whitaker, Mr. Rajiv Menon, King's Counsel, Ms. Charlotte Kilroy, King's Counsel, and Mr. James Scobie, King's Counsel, if they would be prepared, please, to make their opening statements roughly half an hour earlier than they had anticipated. Thank you.